Car accidents rarely have just a single cause. Although a manufacturer could be partially responsible if the front car's taillights don't operate or the rear car's brakes failed, the drivers themselves could have been drinking, speeding, encountered slick pavement, followed too closely, or could have simply been distracted. In Webb versus Navistar International Transportation Corporation, we'll explore whether plaintiffs are responsible for their share of the costs when an accident's cause is attributed to a product manufacturer's failure, and when the action is brought under strict products liability. Navistar International Transportation Corporation manufactured tractors with a tail light, a reflective slow-moving vehicle sign, as well as flashing amber lights. After learning that some cows might have escaped, Bruce Webb and his father got in one of these tractors and proceeded down a dark road with its field light on. However, the tail light and the amber lights weren't working. Despite warnings on the tractor to only carry passengers if a seat was provided, without such a seat, Webb stood on the tractor's bar, blocking the reflective sign. A car subsequently struck the tractor from behind, seriously injuring Webb. Webb sued Navistar based on strict products liability in a Vermont state trial court. Webb alleged that the tractor was defectively designed because Navistar allowed the tractor to operate at highway speeds with a white headlight, but without separate tail lights, and because Navistar didn't provide a safer passenger location and failed to warn of these risks. The jury returned a verdict in Webb's favor. Navistar appealed to the Vermont Supreme Court, arguing that the evidence wasn't sufficient to support the verdict and that the court erred by failing to instruct the jury to apportion liability.